All right, ladies and gentlemen, probably should get on with the business of the city. Today is July 22nd. It is 10:24 a.m. We're here to discuss AO 2022-70, Ordinance Anchor Assembly amending AMC sections 2103.050 appeals, 220.065 Assembly Council, 4.05.090 meetings, and Anchorage Municipal Code regulations 2110.304, 2110.503, 2111.304, 2111.503, 2113.304, and 2113.503 to simplify and streamline the land use appeals. Madam Clerk, you take the roll.
Yes, Mr. Chair. Mr. Constance.
Okay. Here.
Ms. LaFrance. Asked to be excused. Ms. Quinn Davidson.
Good morning.
Ms. Zalatow.
Here.
Mr. Dunbar.
Here.
Mr. Rivera.
Present.
Mr. Boland.
Here.
Mr. Solt.
Present.
Mr. Peterson.
Present.
Mr. Crofts.
Here.
Ms. Allard. Ms. Allard does not appear to be on the telephone.
I thank you. Also,
Mr. Cameron Perez-Garcia.
he is also excused.
You have a quorum.
Thank you. I also have AM 390-2022 with the AO, which is just detail. So, this has Ms. LaFrance's name on it, but it says it is introduced at the request of the mayor. And so, I don't know who would like to take lead. Mr. Conley, I guess?
No, I'm going to refer to staff and legal.
All right, and across the table we have
Adam Tromley, Director of Community Development.
Dave Whitfield, current planning manager.
Quincy Arms, Municipal Attorney's Office.
Dennis Wheeler, Wheeler Law Offices, on behalf of the Board of Adjustments Contract Council.
King Geeks, City Council.
Thank you. Also, we have Planning Director in the back, a couple other folks. Brandon, welcome. And then I guess Mr. Whitfield, you have the floor.
Thank you, and good morning, everyone. Thank you for taking the time to consider this ordinance today. It's the result of roughly a year's worth of work by multiple municipal agencies to include the Planning Department, the Clerk's Office, Municipal Legal Department, and several boards and commissions. Historically, the Planning Department has received appeals to various land use entitlements about once every few years. However, over the past couple of years, we've seen a substantial increase in the number of appeals, which has brought to light some areas for improvement. The existing code and process involves multiple agencies, which creates confusion for the public and staff alike. Furthermore, there exists inconsistent language between current Title 21 and Municipal Code of Regulations. This ordinance proposed corrects these issues and clearly identifies the role of each agency in the appeals process. As I mentioned, this ordinance has been reviewed and recommended for approval by several boards and commissions: the Planning and Zoning Commission, the Urban Design Commission, the Planning Board, and the Board of Adjustment. And with that, I'm going to turn it over to Quincy from the Law Department to discuss the specific amendments to this ordinance proposes.
Unless you have any questions so far. Okay, I'll go. And I'm not going to assume that you read the AM, but if you did, this is going to sound familiar. I'm just going to go through kind of a bulleted list of the different areas that we touched. It would be too much to go through 20 pages line by line, so it's just an overview. The first thing we did was to align the platting board process specifically with the rest of the different boards. Now, every time the planning board makes a decision, instead of doing what's called a summary of action, they will actually draft and propose written findings every time, exactly like the rest of the boards. Let's see, the code was just confusing about what it meant when it said they made a decision, so we're clearing that up. The second big thing that we're doing, as Dave said, there's a lot of confusion internally about which department is handling which part of the appeal. So we're gonna shift a lot of responsibilities from the municipal clerk's office to the planning department. And why we think that makes sense is the planning department provides all the staff support to the land use boards, and so they have the best understanding of all these decisions being appealed and what should be included in the record. So the planning department's gonna compile the record, transfer it to the clerk's office, and they're gonna take it from there. Another big change we did, and shout out to Dennis Wheeler, a lot of help with this, that is gonna be to change the requirements for filing an appeal brief, and we think this is gonna be especially helpful to the public and to the attorneys that actually are doing the filing. It's gonna look more like the court system. We're gonna have, briefs and other motions are now gonna be submitted to Assembly Council instead of the clerk's office to deal with. And the Assembly Council will also be empowered to dismiss cases right away if the very bare minimum requirements are not met for filing. We have better explanation for what needs to be in the brief and how service is executed. Another, maybe the last big change, is we eliminated what's called new evidence or changed circumstances. This was really fraught with confusion. A lot of parties were trying to bring two different actions at the same exact time. One for new evidence to change circumstances, and then separately an appeal. And it was really confusing for all parties involved. So as of now, under this ordinance, the only process available is the appeal process. The other changes are really small changes to the code regulations, like Mr. Whitfield said, just to make it in line with the code. And then, do you want to talk about board adjustment recommendations, or should I? Here? Okay. There's a few other small changes that Debbie did on behalf of the Board of Adjustment.
Thank you, Nancy. To Mr. Whitfield's point earlier about the number of appeals and the impact that has, what we saw at the Board of Adjustment was a lot of motion practice and a lot of extra filings, and it caused all kinds of delay, especially when the Board of Adjustment was required to convene a meeting for every motion, whether a minor motion to extend or something more substantive. So what we've tried to do in building in some of these new processes is provide some discretion to both the Assembly Council's office and the chair of the Board of Adjustment to handle routine motions similar to other kinds of boards and commissions and judicial bodies do it, where those routine things can be passed upon by someone who has at least a minimum understanding of what the requirements are, some basic concepts of due process, etc. So a routine motion for extension shouldn't require the Board of Adjustment to find whether or not its members can meet this month or next month or the third month out. Rather, let the council office or the board chair pass up a motion like that so we can move things along. That should really help speed up the process, because in the past few appeals, part of the delay built into the system is just trying to get the board to be able to meet their obviously volunteer individuals who have other things going on in their lives, and so it's. But that creates frustration for the people affected by the people who have to wait when the court be able to do that. So that's important. I need to get a little closer. Okay.
Speak up.
Sorry. In terms of where the board might diverge a little bit from the proposal was that we had assumed that we would eliminate this first step called the notice of intent to appeal, and instead go right to the appeal process. But my understanding is now that that's going to be the planning department is okay with maintaining this notice of intent to appeal for the minimum purpose of going back to the developer. That's something before it kicked off a process that probably convoluted, a little confusing. The last piece, which could be a little more controversial, deals with the segue between how local enforcement commissions operate in a sort of legislative capacity, providing advice policy, versus how those same bodies acting in the judicial, quasi-judicial process might operate. Under Alaska's open meeting law, a government body performing judicial or quasi-judicial function when holding a meeting solely to make a decision in a proceeding doesn't have to have that public meeting concept. It's not an open meeting for purpose of adjudicating. So we had talked about possibly changing that so that, again, the board could review the briefing and pass around its draft decision and make that decision rendering. Currently, the Board of Adjustment does that in a public meeting, but it takes no public testimony. It's not allowed to take public testimony on the proceeding in front of it. So there isn't a public input into that decision outside of the briefing process. It's all on paper. So this is another way to make things more efficient, would be to allow this board to do that deliberative process in drafting the decision and then produce that decision publicly. Did I miss it? Okay. Thank you.
You know, that's interesting, this idea. How are you imagining, sorry if there's anyone else speaking to you, how are you imagining the process working there when you're talking about eliminating the public hearing process? How do you, just help me walk through a scenario where you have a process? What does that look like?
Thank you, through the chair. So first I might change the terminology from public hearing to a adjudication carried out in public, if you will. So you're not taking testimony in that sense.
Okay.
It's a paper process.
That's fine. So
Yeah.
I understand that now. I think we struggle with the same issue in another section of the code where an administrative hearing officer holds a public hearing. It's not a public hearing in the traditional sense of Title II. It's a public hearing in the sense of their proceedings are carried out in public. And so we're not suggesting that these proceedings take place outside of the public. You're just clarifying the language, or are we saying that they can do this deliberation outside of the public?
We're suggesting that, through the chair, we're suggesting that it's not a proceeding in the same sense that you might think. So, for example, a Supreme Court will accept briefing, and it may or may not have oral argument, but the deliberations don't happen at the dais. The deliberations are really an exchange of briefs and comments and suggestions on paper. And so what's currently happening is the board has to find time to meet. They discuss the briefs. Someone like myself or Dean tries to figure out whatever the consensus was. We redraft, meet again, and so on. There's a cycle, and every time you want to have the board look at your draft, in theory, you're then scheduling yet another meeting. Rather than circulating those drafts amongst the members, they individually make their comments and suggestions and their arguments and calculate that in a final written decision. So it's just a way to speed that up.
So I'll go to Ms. Jones. She has her hand up. This certainly raises a number of questions. Ms. Jones.
Through the chair, the process that Mr. Wheeler is talking about takes, on a good case, 5 hours, and on some cases it has taken over 10, because the board is sitting here in this room. They go through finding by finding and deliberate, and they can't talk over each other. They have to think about the answers and then articulate them. So I just wanted to support Mr. Wheeler's comment that it is very time consuming.
Last question for me, then I'll hand it over to Mr. Dunbar. Do we have other quasi-judicial processes and other boards that meet in this way and address their deliberations outside of the public view and then just come up with a final report?
Through the chair, it's possible that the Board of Ethics is similar to this, And the Board of Ethics, I cannot speak to the legal process, but I can tell you technically that when the Board of Ethics is discussing their opinion and drafting their opinion, they go into deliberative session. And I'm sorry, that's about all that I can accurately tell you about that.
Right, and, that raises a concern because the Board of Ethics deals with very sensitive confidential information that is protected by law, that can't be revealed and made public, but the Board of Equalization, I think, deals with public information, if I'm not correct.
Not necessarily, Mr. Chair. If the complainant to the Board of Ethics has waived confidentiality, it isn't confidential. But what's happening is that the board's deliberations on that matter, even if it's not confidential, are considered in deliberative process.
Right, but that's the outlier scenario though. The standard practice of the Board of Ethics is they have the special privilege in the code to be able to conduct business in executive session, which is very rare. Okay, I'll stop dominating. Mr. Dunbar.
No, I think you answered my question. So the rest of this ordinance, or most of it, is Title 21. This is Title 4, so it applies to all of our boards and commissions. So I guess before Tuesday, I'd like to know, are there any other boards and commissions that are impacted by this change? And if there are, and we don't want to do that, would it make sense to limit this language, say, or when the Board of Adjustment meets solely to make a decision on a motion?
I see Ms. Quincy Arms in the queue. Go ahead.
Through the chair, I don't know the answer, but I will get it for you. It would only apply to accusatory boards, which there are
Right.
very many.
Right.
Right, but again, that creates a scenario where, say, the Planning and Zoning Commission is suddenly doing its work in the dark. And I think that is a recipe for all kinds of scary public
Well,
outrage.
is the planning and zoning? I don't think the planning and zoning is considered adjudicatory.
They do make quasi-judicial decisions all the time.
But their code requires all their meetings to be public. So that would override this requirement.
If it doesn't apply to them, right? You just said you don't know when you'll be back to us. My point was if, in fact, these other commissions are granted this authority, we certainly have to look case by case. Mr. Wheeler.
Thank you, Mr. Chairman. The current version of this draft on page 20 at the bottom says that the exceptions are for executive session, which is current code, and then adding the provision to meet solely to make a decision on a motion. So we would not, the way I meant this was that the motion would be something like a motion for extension of time, motion to supplement the record, motion to do this, motion to do that, and not the substantive decision-making. So to clarify, as written, while the Board of Adjustment would like to be able to do the entire decision in this manner, the current draft is focused just on the motion process to speed things along. That might be a little bit more,
Not being an
more
attorney,
narrow.
is there a term that defines the difference between motions that are procedural and motions that are substantive that might modify that phrase? Because a motion could be a motion to approve the decision, which would be substantive. And so is there a definition, a term that would more tightly bind that statement there to procedural actions?
Through the chair, certainly we could enhance this to make that more clear. Whether standing by itself as it is answers that question, I would defer to Assembly Councilman Ray.
And I don't know that I even agree with that, but it raises my concern when we talk about moving the business to the shadows. Other members? So my question is, how then did this Title 4 section get into this package that's all Title 21?
Through the chair, that was input from the Board of Adjustment themselves. So as is required by code, we drafted this you know, it was a collaborative process all along, but then we forwarded it to the Board of Adjustment, and that was a specific concern of theirs is these procedural motions where they're having to get a quorum to decide to extend a time limit for 10 days.
Okay, so that again seems to me that if I would be more comfortable if we could find a phrase that would really clearly demonstrate we're talking about those things and not the substance. That would be helpful. So I have another question if no one else does. Dean, this relates to this shifting the responsibility, the filing, et cetera, to your office. How does somebody file something to your office?
I'm sorry, my button wasn't working for a second. Well, I imagine that they addressed it to our office, sent it to us. Now, we can stamp it.
So I would offer that, you know, the Assembly Council's office isn't staffed full-time. And so with the clerk, meaning the door's not open all the time, whereas the clerk's office is open all the time. It seems that delivery to the clerk for the Assembly Council's office might be a way to make sure the door is always open. I don't know if I'm scrambling eggs there, but I'm trying to figure out how a person would actually hand deliver, get to you their documents.
Through the chair, I'm sorry, I was helping someone who was in the building. Could you please re-ask the question?
Yeah, so I'm looking just at the very first page, and it's down on line 39, and it says that an appellee shall file notice of intent to file a brief with the Assembly Council's office in the form subscribed. And what I know is, you know, Dean is an office of one at this time plus a staff, and oftentimes those doors are not open. And so a person doesn't actually have a method to do that I'm aware of. Is it possible that the clerk receives these and stamps them in and forwards them, so therefore we always have a door open?
I think that is certainly possible, Mr. Chair, and that may have been something we might have overlooked. If you look through the proposed code and the AM, I think the philosophy that I hope we all agree to was that Assembly Council's office is providing case management services, but the clerk's office is continuing to staff the Board of Adjustment. It staffs the meetings, schedules the meetings, and I thought there were some, we're going to maintain the files. So yes, that is not an issue at all for us if that's a change that we need to make. We also have a lockbox outside the clerk's office so people can even file after hours. It instructs them that the filing date will be the following business day, but I just wanted to let you know that is possible.
Right, so the way that the code now is written, oh, go ahead, Mr. Gates.
I'm sorry. Also there in that section, it says file on a form provided by the City Council's office. We used to be the clerk's office. And so that's one of the tasks that we would be taking out. It's modifying that form to match this. And it's a good point you have, but we will make sure the form instructs how to file for the City Council's office. And as Ms. Jones mentioned, you can work something out where you can file at the clerk's front desk and have it stamped for the time, date, and so forth on behalf of the filing office. I think something like that would work.
So, Ms. Jones, then Mr. Wheeler.
We could also get a lockbox outside of Assembly Council's office for that matter, if that was something that we were interested in. Most people end up filing electronically, which could be part of the instructions on the form. But we can continue to discuss that and figure it out.
Mr. Wheeler.
Thank you, Mr. Chairman. I was just going to say essentially what the clerk just said, that is, we've included a service provision in here, serving documents between the parties and to the Board of Adjustment through the Assembly Council office on page 11. And all that talks about is service that can be done either by mail or email. And in prior cases, most everything was being trafficked through email or mail.
So hand delivery is not a thing.
Some people do it, but I think email or mail is going to be much more convenient for everybody.
So then final question on that topic is, do we need to state that in the code, or shall we just call it a procedure? That the clerk can stamp a document and hand it over?
I think it's a procedure that we create that just complies with the language. I don't think you have to specify it. What's done about that specifically in code.
Okay, thank you. Just trying to visualize how it would actually work. Trying to, as a member of the public, what does this look like? So thank you very much. Are there other questions or inputs? This is not an item that's generating lots of excitement among the body. So,
Yeah, it's a nice change.
yeah, maybe this boring again. Thank you all. This is the work we're supposed to be doing. Okay, if we don't have more questions, I don't think that there's any reason to hold staff. There is a member of the public here, a member of the industry. Are you here for a reason, Brandon?
Just to support what we're doing.
Do you have any specific input, just general?
I can provide a few words if you want.
Yeah, come on up, we'll give you a microphone. Please introduce yourself.
Thank you. Brandon Marcotte here with Triad Engineering. Also representing the Home Builders Association. We've been working with staff for probably well over a year on this change. My office, Triad, has been involved with probably 90% of the appeals that we've seen in the residential industry. And so this change is really important to us to see something streamlined and more efficient process, something that's more clear for everybody, including the public. We were never intending to try to make the process more convoluted or complicated by any means. We were trying to make it more open, more clear, and definitely defining timelines helps, I think, everybody. We've worked with some of our staff in looking at this ordinance, and they've made some good recommendations and helped us kind of craft some language for staff to look at as well, which I believe they've incorporated. So we're fully supportive of it. I think it's great for industry. I think it's great for the public as well. Having clear guidelines of what to send where to whom and for how long is always great for everybody. So we support this fully, and I intend to be there Tuesday as well to support it in person.
You can sign up for telephonic participation by Monday at 5 p.m. So,
I think they have the deadline 2 p.m. or something.
is it 2?
It's
I
still
think it's 5, yeah. So we could call you if we're more
Great.
efficient.
That sounds good.
We gotta sign up for it.
We'd love to have you there.
And we would love to
Chris.
have you. I don't like
Bring
sacrificial
some
lambs.
friends.
Bring the whole association. I need you there.
Happy to answer any questions if you have anything for industry.
Thank you. Thank you. So, anyone else wish to add anything to the record? For my part, the only thing I would like to see, it may not be necessary, is clarification of what kinds of motions can be done by email and in other forms. I guess last question to that. There's a lot of conversation about deliberative process privilege and how decisions are made. Would it be asserted that those deliberations until the final product are not public, or are they public?
Through the chair, I don't think I'm able to answer that one on the fly. My apologies.
You can
As I
answer.
envisioned,
That's fine.
the deliberation would be email exchanges of draft documents. To my way of thinking, they would be subject to potential public records requests, and whether the privilege would apply to them, I would pass it off to Dean.
Yes, thank you. There's actually case law. There's specifically I know senior situation where Griswold versus City of Homer, I think it's 2018. But The court finds there's a balance between public records and the deliberative process or attorney-client, but these types of communications, deliberating the decision of an adjudicative body, not subject to normal, confidential, and privileged. So those part will not be, it's the final decision that would be disclosable, but not those communications in the deliberative process.
So what I heard you say is under the rubric of a quasi-judicial pursuit, these committees' records will not be subject to disclosure except for the final decision.
When it's an internal communication between the board members and the attorney, those wouldn't be disclosable. So if it's a meeting with the parties that's involved in the email communications, those are probably disclosable. Emails between the board members themselves deliberating the decision they're going to make and the attorney, those would not be disclosable under public records.
Boy, as a separate area of inquiry, I'd like to understand how that decision applies to assembly work, but that's another conversation. So thank you very much, everybody. I think for lack of any other questions, we're off the hook. We got done on time, started late. So once again, I'll say for the record, to all the department heads that are listening, you come before us and give us a briefing. It's amazing how smooth things can be when you get to the floor. Thank you for your time.